we shop, and wish you all well in the deliberations coming. I thank you for your attention.
Thank you very much, Minister Kadebe, for his very inspiring words. And of course, we will debate what you're recommending to us. And at the end of this workshop, we will come to a definite conclusion and get back to the national officials. We're now going to go to a short ad break. Please stay tuned and remain focused. We'll get back in about 3 minutes. Thank you. Okay. Okay, yeah. Everyone must be seated. Okay.
Say what? He's on lapels. Yes.
Mosheshwe. Yeah, yeah.
Okay.
Okay. Okay. Okay. Okay. Yeah. Okay. Short and brief. Yeah, but they got 15 minutes. Yeah, 15 minutes.
15.
Okay.
I'm not 15 actually.
Yeah, okay. Okay.
No, it's got to be nice now.
Yeah. Welcome back. Our first speaker is the Deputy Editor of the South African National Editors Forum. He's a journalist of note, also the acting editor of the Mail and Guardian newspaper. Welcome, Mr. Moshweshwe Monare. Thank you.
Many thanks indeed, and I would like to acknowledge the presence of the Minister and thank you for your inspirational and encouraging words, and I also acknowledge the presence of Advocate Pansy Tlakula. I must say it fills me with the great sense of hope to see politicians, lawyers and journalists under one roof and agreeing on something for a change. And lawyers not expecting payment, and journalists not expecting exclusive front page scoop, and politicians not expecting free publicity. The South African National Editors Forum is fundamentally opposed to any form of criminalization and unjustifiable restriction of free speech. We view criminal defamation as a direct attack on freedom of expression and the media. Criminal defamation undermines and represents a radical departure from the democratic values of openness, freedom, and accountability. It offends the principle of a free society that is underpinned by free exchange of ideas and expression. We were therefore shocked and disappointed to hear Judge Molefe in the Motsepe case confirming that criminal defamation was a justifiable and reasonable limitation of freedom of expression. We are not legal scholars, but just law-paid journalists. But we believe that our court's interpretation and reaffirmation of this crime failed to take into account our constitutional values that are supposed to give texture, purpose, and character to our jurisprudence. Had they done that, Judge Molefe and others would have realized that criminal defamation has no place in our common law. We hope our high courts will discharge their constitutional duties of developing the common law to reflect the prevailing values by questioning the relevance of this crime. Criminal defamation must not be tolerated in post-apartheid South Africa. We have adequate legal and constitutional guarantees to protect the dignity, privacy, and reputation of the defamed. At least not all our judges believe in the criminalization of free speech. Former Gauteng Judge President Bennett Mwepe, as the Minister has alluded to, agrees that defamation is not a crime but a civil matter. In his minority judgment in the Konate case in the African Court on Human and People's Rights, Mwepe wrote, and I quote, "Criminal defamation is an unjustified restriction to the rights of freedom of expression. There should have been no punishment based on criminal defamation at all. The aggrieved person should have resorted to other avenues than to criminal recourse." I must say it's a shame that in South Africa in 2015, journalists or anyone wishing to express herself or himself within the limits of the Bill of Rights could face a threat of arrest, prosecution, and possibly imprisonment and fine. When facing a charge of criminal defamation, you are effectively a crime suspect, and the complainant has the disproportionate power and the assistance of state institutions at his or her disposal. Journalists must never, ever operate under such threats, especially when some of our politicians are flirting with the idea of insult laws. According to the Committee to Protect Journalists, there were 221 journalists last year. Even though none of the imprisoned journalists were in South African jails, the arrest and initial conviction of Cecil Motsepe, former Sowetan journalist, for criminal defamation has a chilling effect on freedom of expression. It effectively criminalizes the practice of journalism, and we find that as very unacceptable. It triggers the traumatic memories of apartheid security laws in which the executive could use the might of the state to stifle free flow of information and the public's right to know. One of the primary roles of the media in a democracy is to hold the powerful accountable, fight for the voiceless, and inform the public. And we believe that criminal defamation restricts this role. It negates the values envisioned by our founding fathers and mothers who gathered not so far from here more than 2 decades ago to make sure that never again shall journalists be detained for their thoughts, expression, and for what they write and stand for. It is reassuring, however, that the ruling party, the ANC, believe that defamation doesn't belong in the criminal sphere of our law. It is for this reason that this workshop signifies a rare but crucial partnership in the campaign against criminal defamation. I personally still don't understand why criminal defamation is not abrogated by disuse. Someone mentioned at the Freedom of Expression Institute April seminar that even some lawyers are not aware that criminal defamation is still part of our common law. We all laughed, actually. But it's true, because in the Motsepe and Hoho cases, one of the key questions the courts had to answer was whether the crime was still extant, because it's rarely prosecuted. And when it is prosecuted, the complainants are usually the prominent and the powerful. Ironically, these are the very same people who have enough resources to institute expensive legal defamation cases. Ordinary citizens do not necessarily benefit from criminal defamation protection. Therefore, there is no basis to retain it. However, doing away with criminal defamation doesn't give journalists the power to defame and impair the dignity and reputation of others. The elimination of criminal defamation will not be a license to defame with impunity. As we all know, our constitutional drafters did not make freedom of expression paramount. It competes with other constitutional rights, such as privacy and dignity. Our Bill of Rights also offers adequate limitations. Therefore, removing criminal defamation from our common law doesn't deny the defamed the right of recourse. They can be awarded damages for ruined reputations. They can also be awarded interdicts to prevent irreparable harm to their reputation. They have free access to the Press Ombudsman and the Press Council Appeals Panel, currently chaired by Judge Mwepe. In his address at the Freedom of Expression seminar in April, Judge Mwepe also said that where criminal defamation has amounted to incitement, there are laws to protect such crime. There are laws to prosecute such crimes. As SANEF, we will support any campaign or processes that could lead to the decriminalization of defamation. Lastly, just to veer a little from criminal defamation, I wish and hope that we will meet in a similar forum or workshop to tackle other threats against the media, such as the proposed statutory media appeals tribunal. I thank you.
Thank you, Moshweshwe. We're now going to a short break. Thank you.
You can just stand, sir.
So I don't need to use a mic, eh?
No, you're going to use
this. I'll use this. It's
Next
perfect.
time we're going to change it, but then it will be better.
I think so. I just hope I don't fall on this.
No, you won't.
Okay. Should we swap? This process that is fraught with occupational health and safety risk.
Thank you.
I'm going to be trying to say mine's going to be a bit more challenging.
Rattle on a bit on
Yeah.
this topic.
Yeah.
Given once they
Oh.
and the more people speak, the more you want to respond.
Well, exactly. Well done. Very nice. To the point. No, that was good.
Dario Milo,
was very good.
M-I-L-O.
I'm doing a little bit about why, because you know the title, Charlie Hebdo. So I'm going to do a little bit about why this is not hate speech. So just to, okay.
Yeah. I think it's
Yes?
important to make that distinction upfront.
and then a little bit of basics, which I've cut down a bit on what is different between civil and criminal. But I think
Two, so if you
okay.
cover that, that's
Okay.
great.
Okay, all right. Well,
I think that's
Yeah.
important. And what
Okay.
you'll say, if it's different from hate speech, and the civil and the
Okay,
criminal
thanks.
distinction is drawn,
Okay.
and a lot of clarity.
I think so.
I'm going to go into the difference between having the rights and having the enforcement.
Okay.
And the enforcement of rights. Don't forget
I like
Mr. and we can include that.
Yes, I must recognise them. Yeah. Okay.
Yeah, I'll just after.
Oh my goodness, you have to go. Okay, on the panel. Okay. I hope she's okay.
I spoke to Pansy. She'll comment later.
Les, obviously you have my offer to help with the legislation, you know, and on behalf of SANEF and others, yeah.
No, thanks. I picked up last night that don't steal my thunder on this.
Thank you.
There's a decision of the African court to directing Burkina Faso to change its legislation.
Oh, no, I won't touch on that, but I didn't know about that. Okay, that's brilliant. Okay. Okay, that's excellent. Is that as a result of this Konate decision?
Yeah.
So there's been another one where they've said, no, you've got to actually...
This is apparently is part of it.
Yeah.
It's the same decision.
Okay, because I'm simply dealing with that decision, the facts and the rationale, but not that aspect at all. So
There's
you
an
can...
order you Burkina Faso must.
Okay, I didn't study the order. But that's,
According to the reports I read.
I'll leave that to you.
Okay, thanks.
Thank you and welcome back to our viewers and listeners. Our next speaker is a renowned media lawyer, written several books, a partner and attorney Weber Wenzels in Johannesburg, Mr. Dario Milo. Thank you, Dario.
Thank you. Thanks, everyone, and good morning. And I'd especially like to acknowledge the presence of the Minister and Advocate Lakula. It's a great privilege to be able to address you today. I want to do 4 things this morning, briefly. First, I want to say a little bit about the difference between civil and criminal defamation. And, of course, many of you will be aware of this, and I apologize for that. But I think some of the basics are important to get out the way. And also a little bit about its history. Secondly, I want to talk about how criminal defamation differs from hate speech. Many of you would have seen in the title for the workshop a reference to Charlie Hebdo, and I'd like to talk about that very briefly. Thirdly, I'll look at the recent developments in Africa and jurisprudence as it's developing. And in particular, I'd like to look at the Zimbabwean Constitutional Court's decision of last year and the African Court's decision, which are both seminal decisions and cases in the field of criminal defamation law. Finally, I'll briefly set out what the South African legal position is, although my learned colleague Les Morrison will deal with that in a lot more detail. But I'll argue that criminal defamation is plainly unconstitutional, and the ANC's decision and the Minister's announcement that it will be eradicated from our law is clearly the correct constitutional decision. So firstly, let me begin with a brief working definition of how the civil law of defamation differs from the criminal law. Civil defamation, as you'll know, is a legal remedy to compensate people for harm to their reputation. The object is the vindication of their reputation, where they have been unlawfully defamed in the eyes of reasonable people in our community. And examples are many. I've been involved in a number of cases, and the facts, of course, differ. But to give you two examples, in LaRue versus Day, in the Constitutional Court, the deputy headmaster of the school sued three students who created an image of the deputy headmaster and the headmaster of the school in a sexual position, and the deputy headmaster thought that that harmed his reputation and sued. That's the one category of case. And of course, there are many cases where high-profile and prominent people sue for defamation, such as Robert McBride suing The Citizen for publishing editorials and columns that stated that he was a murderer who ought not to be appointed to important public office. So our law allows the successful plaintiff in those kinds of cases who succeeds in showing defamation, and where the defendant does not succeed in showing a defense, to claim damages, to compensate for the harm to their reputation, an apology, and even an interdict to stop further publication of that defamatory statement. Criminal defamation, on the other hand, is of course enforced by the state. A charge gets laid against you, the police investigate the charge, you may be arrested, there may be a prosecution by the National Prosecuting Authority, and if a court convicts, the defamer is punished either by a fine or imprisonment. The purpose of criminal defamation, though, is also the same as the purpose of civil defamation, and that is to restore the complainant in that case's reputation. And therein, of course, lies most of the constitutional difficulty, that you already have the purpose of the criminal law achieved by the civil law, and I'll come back to that. How did we get here? How did it arrive in our law? And the Minister has already referred to its origins and its colonial origins. Essentially, we have a combination of Roman Dutch law, who inherited the concept of criminal defamation from Roman law, and English law. In early Roman law, someone who recited words that harmed another person, particularly a person in public office, was a crime, and it was punished with the death penalty. In the 17th and the 18th centuries, the crime was regularly prosecuted in Holland and was seen in a very serious light. And so it was imported into our law. Commentators have said it's difficult to discern the precise rationale, but some authors trace it back to the desire of those in power, and particularly rulers and governments, to maintain the social class structure and the status quo. And even in England, the crime was abolished in 2009, with the then Justice Minister saying it was an arcane offence from a bygone era when freedom of speech wasn't seen as the right that it is today. I need to take a very brief detour here just to distinguish hate speech laws from criminal defamation laws. In my view, hate speech laws may well be constitutional, as long as they are narrowly tailored to reach the threshold for hate speech which is defined in the Constitution. As you'll know, Section 16 of our Constitution has a broad protection for freedom of expression, but Section 16.2 excludes from that protection a number of categories of speech, such as incitement of imminent violence and also hate speech, being the advocacy of hatred based on race, ethnicity, gender or religion, and which constitutes incitement to cause harm. So unlike words that are defamatory, which are, as a starting point, protected by our Constitution in Section 16, and then there's a balancing that occurs with dignity and reputation, hate speech is expressly not protected under our Constitution, and justifiably so, because of our history. So narrowly tailored hate speech laws, unlike criminal defamation laws, would be defensible in our democracy. Now that I've set out the basics, I'd like to discuss some very positive developments around the continent in the last year. And in fact, the place to start is in 2010, with the resolution of the African Commission on Human and People's Rights on repealing criminal defamation laws in Africa. The Commission said, criminal defamation laws constitute a serious interference with freedom of expression and impede the role of the media as a watchdog, preventing journalists and the media from practicing their profession without fear and in good faith. Despite this resolution, no progress had taken place. But all this changed with two decisions last year, a December decision of the African Court on Human Rights and a June decision of the Zimbabwean Constitutional Court. I'll begin with the African Court decision, which dealt with the law of criminal defamation in Burkina Faso, which of course is also in the news at the moment. Konate, a journalist working in Burkina Faso, was charged with criminal defamation for defaming the state prosecutor. He was convicted and sentenced to 12 months imprisonment. He was also given a severe fine, hefty damages, ordered to pay costs, and his weekly newspaper was banned for a period of 6 months. He approached the African court, and I'm happy to say that the court unanimously found that Konate had been wrongly imprisoned. The majority of the court, 7 judges, found that criminal defamation was not necessarily bad in principle, but a huge problem was the sanction of imprisonment. And the judgment found that criminal defamation, therefore, could not be punished via custodial sentences. It was an important advance in our law of criminal defamation. The court, incidentally, also overturned the other remedies that had been granted against the journalist. So the banning of the newspaper, the damages, the costs, all of that was regarded as disproportionate. But it's noteworthy that our very own Advocate Tlakula, who's here today, the Special Rapporteur, says in response to that decision, this is a landmark decision that will change the free speech landscape on the African continent. It will give impetus to the continent-wide campaign to decriminalize defamation and also pave the way for the decriminalization of similar laws. Now, the minority judgment in that case of 4 judges, including, as you heard earlier, the former judge president of Gauteng, Judge Bernard Ngwepe, rightly took the view that, in fact, the main judgment didn't go far enough, as welcome as it is. And that is because there is, in fact, no place at all for criminal defamation in the first place. It's not necessarily about the sanction. It's about whether the crime itself is constitutionally justified. And that brings me to the earlier decision of 2014, the Zimbabwean Constitutional Court's decision, where the court unanimously struck down the crime of defamation. It held it was not reasonably justifiable in a democratic society. And the court's decision is profound for a number of reasons. And of course, it was awarded this year's Columbia University Free Speech Decision of the Year. And that is competing with other countries such as the Turkish Constitutional Court's decision on Twitter and other very, very important free speech developments. But in the context of the arguable pressure that the Zimbabwean judiciary faces, this is an incredibly important decision, and it's an incredibly brave decision. It shows that this court, like ours, is truly independent of government and decides cases without fear or favor. What Judge Patel for the unanimous court ultimately decided was that the overhanging effect of criminal defamation is to stifle and silence the free flow of information in the public domain. This, in turn, may result in the citizenry remaining uninformed about matters of public significance and the unquestioned and unchecked continuation of unconscionable malpractices. And the court said the alternative remedy of civil defamation was sufficient to provide vindication to a person who has been defamed. And there was therefore no necessity for Zimbabwean law, in accordance with free speech in its constitution, to also have a crime of defamation. This finally brings me to South Africa, where I won't go into great detail because, as I say, Advocate Morrison will. Our Supreme Court of Appeal, in contrast to these decisions in 2009 in the Hoho decision, held that criminal defamation is constitutional. It rejected a challenge to the constitutionality. We thought at least we could distinguish that case because it didn't involve the media. But when a media defendant was involved, a media accused, that's Motsepe, as Moshweshwe has referred to, unfortunately we were not able to persuade the court that it was sufficiently distinguishable from the Hoho decision, and a different rule should apply to the media. There shouldn't be criminal defamation, at least for the media. Of course, it had a happy ending for Motsepe, the case, in the sense that his conviction was overturned, but that was on the basis of dolus eventualis, which anyone who followed the Oscar trial will, of course, be familiar with. But the judges expressly rejected the opportunity to say that our law has advanced and developed such that criminal defamation should no longer be a part of our law. So while other nations around the world and the continent have taken the correct steps to eradicate this unconstitutional crime from the law, South Africa is now a step behind. And as the minority warned in Konate, this is a step backward in the evolution of human rights in Africa. Hoho took that backward step, and the opportunity to correct it by the judges in Motsepe was unfortunately squandered by the court. My last point is that the minister's announcement today that the ruling party wishes to decriminalize the crime of defamation and that there will be engagement with civil society to achieve this is not only to be welcomed but to be celebrated. Eradicating criminal defamation from our law will do the legacy of Nelson Mandela proud. As he said back in 1994, with an eloquence no lawyer or judge has ever been able to match. A critical, independent, and investigative press is the lifeblood of any democracy. The press must be free from state interference. Criminal defamation is exactly the kind of state interference which impacts significantly on freedom of the media in our democracy. The sooner we get rid of it, the better. Thank you very much.
Thank you very much, Dario. We're going to take a short break and we'll be back. Thank you.
Thank you.
Hello? Yeah, I'm here. Yeah. Okay.
Thank you.
Okay. But I need to know what number the public is going to phone in on after the last speaker, because we're going to take calls from the public. Sorry?
Here we go.
Hello?
Not at all. Not at all. There's not much of that to do in the first place. You've got to be careful with
Right.
the aerosols.
Yeah. Okay. Okay.
We're good?
At the top button. The mic is in the,
What
it's
do you
there
wanna
at the
do?
top. Okay. Can you put the button?
What do you want to do? You want to put it on the collar?
No, we're just trying to get the button organized. Which button? Which button? The top or button? Because the mic is there. Is it okay? It's okay. Okay. Yeah. Thank you. Welcome back to our listeners and viewers. Our final speaker on this topic of criminal defamation is Advocate Les Morrison, SC. Les is a member of the ANC Legal Research Group and also a practicing advocate at the Johannesburg Bar. Les?
Thank you. Morning, thank you. I acknowledge the Minister and Advocate Lakula. It's an honor to be able to speak in your presence, and thank you, Mr. Minister, for those inspiring words. I, with respect, have been briefed to be something of a devil's advocate on the topic and to argue for a limited retention of elements of criminal defamation and to explain how our courts have come to the conclusion that it should remain part of our law and that it is in fact constitutionally sound. And at the outset, I'd like to pose this question to you because it was one of the persuasive questions that was asked by the court in the decision of Ho-Ho. And that was a very illustrious bench of the Supreme Court of Appeal with very impressive judges coming to that conclusion. And that is, if there is a civil remedy for physical assault and a civil remedy and a criminal remedy for physical assault, why shouldn't there be a civil and a criminal remedy for assaults on one's reputation? And the answer is quite clear in my submission. A criminal sanction performs a different function, and a civil remedy is available actually only to private citizens who can afford to get to lawyers. So when we look at retaining the criminal component of any aspect of our law, what we are saying, in effect, is that the police, the criminal courts, the prosecuting authority are available as a state service to protect the reputations of people who might otherwise not be able to afford to obtain any legal remedy at all. And what I'm asking is that we look to the poor people, the people without access to private lawyers. We shift the paradigm of this debate away from the press versus powerful public figures. And we ask ourselves, how would a rural person facing a whispering campaign of being involved in witchcraft or other highly malicious whispers against them that might affect their employment, that might affect their political aspirations, that might affect their opportunity to marry the person of their dreams, how do they protect themselves other than through approaching the police? There are no private lawyers practicing in the far-flung parts of our country where reputations are equally, if not more important. And if criminal defamation was removed in its entirety from our common law, it would be a free-for-all, and one would remove the very important sanction and the services of the police, the prosecuting authority that are located in those areas, and the criminal courts that are located in those areas, and send the message that it's not permissible to behave in this fashion. And so we must bear in mind the reputation, which is what defamation is about protecting, is a vital part of the right of dignity, and it enjoys fundamental protection in our Constitution. So when one speaks of defamation, one's not talking merely of journalists pointing out corrupt officials in high places. One's also talking about people who have very important rights of dignity, and our courts have emphasized again and again, as in Ho-Ho and in Motsepe, that dignity is the counterbalancing feature to freedom of expression, and courts are engaged in that balancing act all the time. And there is no widespread abuse of criminal defamation laws in our society. Our courts have been acting independently. Our courts have taken a very balanced view to it. And in the case that is the subject of this particular workshop, Motsepe, let us bear in mind that Motsepe, the journalist, who took a court record, got a lawyer to translate it for him, which was a bad idea in the first place, worked off the lawyer's say-so as to what the record said, and then published a highly defamatory article about a magistrate to the effect that the magistrate was a racist. and that the magistrate used different forms of decision-making processes for one race as opposed to the other. That magistrate's reputation was severely hammered and damaged by that allegation. But Matsepe was acquitted. On appeal, he was acquitted, precisely because it's very difficult to prove that somebody is responsible for criminal defamation. He was found not to have had the intention because he'd got it wrong. He thought what he was publishing was true. He thought what he was doing was correct. He thought that the lawyer that advised him was correct. And therefore, Matsepe was acquitted. So the way our criminal defamation law works is not as onerous as in some countries where it's used to oppress journalists and limit freedom of speech. Our Ho-Ho decision is another important example where a particular official, a researcher in a government department, was publishing secret pamphlets accusing high-ranking people with very responsible jobs of sexual impropriety, of corruption, of theft, of dishonesty, of tender rigging, 22 separate counts of a campaign of secret pamphlets that would never have been exposed had it not been for the involvement of the police. And I ask you to bear in mind the role of the police in criminal defamation. They investigate. They are the first port of call for enforcing the laws of our country, and the criminal laws of our country must be made available to those who face these campaigns. To take the facts of Ho-Ho, one would picture maybe 10 different officials, all as plaintiffs, all going to see individual lawyers, all bringing separate cases to the civil courts against one individual who might be quite difficult to track down and who would be quite incapable of paying the damages awards necessary, because that's one of the other problems with civil defamation, is that even if you can afford as a defamed person to go to court to get a lawyer to represent you, the person you get the award against in a monetary fashion may not actually feel the consequence of that because they may be impecunious. So to pursue the rights of the persons who were the victims of the defamation in Ho-Ho, people entrusted with the development of our democracy, people entrusted with important public functions, in order to get those people protected in a civil remedy would have been a big, arduous, expensive case that would probably not have achieved very much, whereas a criminal defamation charge was instituted. 22 of them were instituted. And the court was required to decide whether or not at the Supreme Court of Appeal level whether those charges on which he was convicted should stand. And let's put it bluntly, a cancer in our political structure was eliminated. That was very focused, radiation beam focused on that particular malevolent cell, and he was nailed by the criminal law of defamation in order to protect those officials who were quite wrongly defamed. So I would argue that we need to retain the criminal law of defamation, but we need to follow the lead of the African court, which is to remove the sanction of imprisonment. Because that's what was decided in the decision against Burkina Faso, where the gentleman that Dario spoke of was the publisher of a newspaper called The Hurricane. And he alleged that a public prosecutor was guilty of corruption. And he was found to be guilty and subjected to imprisonment for 12 years, or 12 months. And what the African Court on Human Rights decided was that he should not have been imprisoned, and it gave a direction which is binding on all African Union states to remove from its statutes books and from its laws, to the extent that it was common law, the sanction of imprisonment for criminal defamation. And I would argue that in the very welcome approach that our party wants to make to change our law of criminal defamation, that we should retain it to a limited degree, but eliminate the threat of imprisonment, because that is probably going too far. And sentences of community service, sentences of fines for appropriate defendants would be a better way of modifying our criminal defamation law, but still retain to those of our people who need access to that form of protection. Young people using cell phones, being persecuted in cell phone campaigns, who don't have access to private lawyers. Social media journalists who don't have access to private lawyers, but play an important function in keeping the exchange of ideas going in our society. those people need to be protected by a more temperate, more humane form of criminal defamation. Thank you.
Thank you very much, Les. We're now going to go into a very interactive debate on the topic. We've had a cross-section of views expressed by our speakers, but before that, we'll take a short break. Thank you. Hello? I'm listening. It's Advocate Pansy Slakula. Okay. Yeah. Okay, they're doing that.
Thank you. You'll tell me. I know.
Okay, let me just check. Anyone want to speak? On the topic? Anyone want to speak? Another lady. Okay. Yeah. You come in a bit later towards the end.
Sven. So
Yeah.
the minister's going to speak on the
Amir?
red mic. She's going to speak on the red mic. If anybody else is going to go, it's
Amir?
going to be on the silver mic. Okay. On this one.
Okay.
Sorry, so I'm just going to put this mic. I don't know. I have no idea. No, they're not. Okay.
Come there. When I call you, you come there to face there.
Oh, I see. Okay.
Okay. Yeah. Okay. Thanks. Thank you, Tumi, and welcome back. Just to introduce Katie Katapozis, who's here representing SANEP, taking over from Moshwefe Monare. Our first speaker to kick off the debate, ladies and gentlemen, is Advocate Pansy Slakula, who I introduced earlier. She's served the past 10 years as a special rapporteur on freedom of expression and access to information of the African Commission on Human and People's Rights. Advocate Slakula.
Thank you very much, and good morning to everybody. Let me acknowledge the presence of the Minister and also thank the ANC for convening this discussion. I am so pleased that we are having this discussion, particularly because it has been a very long road for me as the Special Rapporteur on Freedom of Expression and Access to Information in Africa. From 2010, as Dario has said, when I sponsored the resolution on decriminalization of defamation in Africa. And at that time, when I sponsored that resolution, it was even difficult to convince my colleagues, the fellow commissioners, of the need to decriminalize defamation. And we are not only talking about defamation, I think we should also be alive to other laws that still exist on the continent, like insult laws, publication of false news, and sedition, because these laws are used in many parts of the continent to stifle free expression. And to say that I feel so pleased today because, you know, we all say charity begins at home. I have been going to many parts of the continent trying to campaign and advocate for decriminalization of these laws, and yet in my own country these laws do exist, because when you go to other parts of the continent, people ask you, what about your own country? Why do you come here? Why don't you start at home? So at least, Minister, going forward, I will be able to say that our country has now committed to doing away with these laws. And I hear what Les is saying, but in the work that I do, the people who bear the brunt of these laws are not ordinary people. I've never come across a case where I've had to intervene in a case regarding an ordinary person who has been defamed. I write many letters of appeal. I intervene in most parts of the continent from Cairo down. And who are the people who are persecuted or prosecuted using these laws? It's journalists, human rights defenders, and opposition politicians. I am yet to come across a case where an ordinary person has lodged a complaint with the police on criminal defamation. I'm also pleased that I see among us people that I work with, because we, as I've indicated, in 2012, in Tunis, we launched a continent-wide campaign to have these laws decriminalized. And I see people who are part of my campaign in this room. In fact, when we leave here today, we have a 2-day meeting to discuss how we're going to intensify the campaign to decriminalize campaign post the Konate decision, because post-Konate, we have to ensure that, decriminalization process gains traction on our continent. And finally, to say that it's been a long, long road, again, since the adoption of the Table Mountain Declaration that also gave impetus, started this campaign. And to remind all of us, free expression activists, that next year marks the 25th anniversary of the Windhoek Declaration. And it will be good, Honorable Minister, if South Africa helps us to commemorate the adoption of that important document by decriminalizing defamation in this country. I'm hoping that in 2016, criminal defamation in South Africa will be a thing of the past. Thank you very much for giving me the floor.
Thank you, Advocate Zakula. Right, we're now open for questions, comments from the floor. Yes, ma'am.
Thank you.
Your name and organization.
My name is Justine Limpertlaw, and I'm on the working group of the Decriminalization of Expression campaign in Africa, and I'm also a board member of Media Monitoring Africa. And I just want to say to the Minister, in particular, it's a very emotional day for me to hear those wonderful remarks and to see the ANC once again, in my view, playing that liberation role for all of us and for media freedom that I have long associated. And I'm very grateful for this. And now I need to stop being emotional because I've got a couple more things to say. The one thing is that criminal defamation is currently trending as the #1 topic on Twitter. This, on a day when our rugby team is playing its first World Cup match, is extraordinary. So it's amazing what's happening in this small room. And then secondly, Minister in particular, I want to ask if the ANC government will please take up the issue of eradicating criminal defamation in all of the SADC countries, because journalists are really suffering in Southern Africa under these laws. We know they're a colonial throwback. They were meant deliberately passed to suppress African people and African voices. And we need your help. The region needs South Africa's help in getting rid of this. So please work with us at SADC to promote the eradication of criminal defamation for the whole region. Thank you.
Thank you very much, Justine. Are there any more comments, questions from the floor? Yes, sir.
Hi, my name is Timothy Maurice Webster. I would like to put on the table, I work with, I'm a thought leader and an author. I participate in media on a number of platforms from Metro FM to CNBC Africa. And one of the things I'm concerned about is the fallout after the eradication. I feel that the media often disrespects the ecological order of many sort of African cultures. And the impact of reputation and defamation is different in each society. And to defame someone from certain communities with certain cultural principles can have larger impacts than someone who comes from sort of a Greek personal agency society versus sort of a collectivist society. So while I agree and I understand principally from a democratic, from a legislative, from a democratic dynamic, the fallout from the life force principles from an ecological order perspective when a journalist attacks someone who comes from a collective society will be extraordinary. To brace yourself and put conditions in place to be able to absorb that fallout is something that must be put on the table.
Thank you. Thank you very much for that. Please, we've got a representative from SANEF here, Katie.
Thank you very much. I want to say that I think we need to strike a balance here. So while we most certainly welcome this conversation around criminal defamation leaving our law books, I think as journalists and as editors, we have a responsibility to report ethically at all times. It cannot be a free-for-all as we've heard earlier today, but it needs to be something that we really strike a very careful balance when reporting. We cannot think now that this is a go-ahead and it gives us the go-ahead just to go and say what we want, when we want. The basic fundamentals of journalism that guide us, the principles and the ethics, need to remain very, very firmly in place.
Thank you, Katie. You want to say something, sir?
Yeah, I just wanted to, I guess what I wanted to ask has been covered by what she just said, because I wanted to say perhaps in countries where decriminalization of defamation has been exercised, have we perhaps seen the quality of reporting going down, or has it stayed constantly? Perhaps those are things that need to be looked at, because as consumers of news, you want to see quality of news coming through to you.
Thank you very much. Is there anyone that wants to put questions to our speakers? Dario, Les?
Dario, this question is more geared towards you and also perhaps to you, Les. By the way, my name is Ahmed Kaji. I'm an advocate at the Johannesburg Bar and a member of Advocates for Transformation. Many instances of defamation would also constitute the crime of crimen injuria. So where would you draw the line between the two, if you have to draw the line? Because I believe crimen injuria is defined as unlawfully, intentionally, and seriously impairing the dignity of another person, whether by words or by actions. So that would be my question to the two of you.
I think it's a very important question. The jurisprudence around crimen injuria tends to focus on personal insults and dignity invasions, as opposed to, should I stand up? Sorry, let me repeat that. The jurisprudence around crimen injuria focuses on personal insults and dignity invasions, as opposed to widespread publication, which is where you're in the realm of defamation. And that's why typically, as Advocate Lakula said, the media and journalists and activists and unionists and campaigners, opposition parties, are the target of criminal defamation lawsuits or criminal defamation prosecutions, because it is a widespread publication thing. For crimen injuria, you're talking about, and for instance, there's a recent case at the Supreme Court of Appeal where the K word was used, and where the Supreme Court of Appeal gave a very resounding judgment as to why that is absolutely unacceptable in our democracy and deserves punishment under crimen injuria. So I think that the two topics are very distinguishable. It's true that there's an overlap at the level of theory, but I think once criminal defamation is off the law books, crimen injuria will really be confined to those cases where legitimately there are, racist statements, insults, harms to dignity on a personal level, and where there's an appropriate criminal law response to those situations. Les, I'm not sure if you want to add to that.
Thank you. I would just say, in relation to Motsepe's case, where you've got a magistrate accused of racism in his professional capacity, he is being defamed. His reputation is what's being impaired. He's not merely being insulted by insulting language. It's not merely his dignity. It's a component of his dignity that means his entire profession, and in fact the dignity of the office that he holds is being impaired. And in that situation, I think the criminal defamation has got an important different function, because reputation goes beyond mere dignity. Thank you.
Thank you, Les and Dario. Advocate Sabeko.
Thank you. My name is Mkabela Sbego. I'm the advocate based in the Johannesburg Bar, also a member of the ANC Legal Research. I am slightly concerned that the debate has actually been very unidimensional and a bit idiosyncratic, in that it is a debate involving the powerful, the media, and perhaps purported high-ranking, government officials, who are both resourced and can actually go and dig deeper into their resources if and when their sort of space is invaded. Very little has been said. I would love to hear more on the side of SANEF to say the powerless, because I listened to Advocate Penzitlakula saying these things are not reported. But the reality of the situation is that the media, being those people that are in a position to set the agenda and decide what's reported, turn a blind eye in instances where the weak and the powerless have their rights to dignity, not to be defamed, attacked. I would love to hear what serious attempt is going to be made to ensure that even the powerless are brought onto the agenda, as it were. Thank you.
Thank you, Advocate Sibeko. Katie, would you like to respond to that, or any other members from SANEF?
Yes, thank you. Would you like me to stand? Thank you for that. I think it's a very important point in terms of the powerless. I think as the South African National Editors Forum, we certainly do not prescribe to newsrooms in terms of who should and who shouldn't be covered, in terms of powerful or those in the know, or those who have very strong voices and very loud voices. Our mandate as journalists is to tell a story in South Africa, the unfolding story, be it on a political, social or economic level. And that often includes the powerless, as you describe them, sir. It often includes people who don't have a very loud voice. But we've seen many stories in the media of late, in fact, of those who don't historically have a very strong voice, but we are telling their stories. And I think what we should be doing as SANEF is encouraging our newsrooms, our reporters, our editors to keep telling the stories of South Africa, whether good or bad, by the way, because we hold a mirror up to our society and we need to reflect the goings on in our society. So I certainly don't think that something like criminal defamation will take the voice away from the powerless or the poor or the weak, as you describe them. I think we just need to be strong in terms of focusing on all those who have a story to tell within South Africa, be it good or bad, as I say.
Thank you, Katie. Is anyone else from SANEF that would like to contribute, or civil society organizations, sir?
Hi, Wynand Goosen. I work in education and training, and I would just like to perhaps just one or two words in terms of whether it's decriminalized or not decriminalized. I think one needs to anchor the debate in terms of systems thinking, and simply maybe bring it back to what is the value base of our society. Because we're talking about what do we do when these type of events happen. But I would like to pose the question, what do we do to prevent these types of questions happening and these sort of situations occurring? And the answer lies in reintroducing the value base in our society. For example, I think that where we are right now in our country, our moral fiber is deteriorating, and I think that from young people's perspective, they have very little guidance, very little leadership in terms of what they should and shouldn't do. And I think we need to just bring it back in terms of how do we behave in relation to one another before we start thinking in terms of what the law should or shouldn't be. Thank you.
Thank you. Gentleman there.
Hi, my name is Nimrod. The question that I want to pose is directly linked to SANEF and Katie, to you in particular. Now that I've acknowledged that there has to be a balance act, what is SANEF's position insofar as the recourse for those who have been defamed?
Thank you. Before taking Katie's response, one more question.
Well, it's not actually a question, it's just a comment. Hassan Kaji, I'm a member of the ANC Legal Research Group. I don't want to promote ANC politics as an ANC member, but all I want to say is that there was a famous historian, Voltaire, that said, I may not agree with what you say, but I will fight to have you say it. And we all know who was responsible for liberating this country. In view of that, we must acknowledge, as the minister has rightly said, 21 years now, we are slowly maturing as a democracy. Our past was very dark, but now, if you want to have democracy go strong, you have to get people to believe that they must be allowed to speak without fear and without favor. And if you want to build intellectual capital in this country, you've got to encourage debate. And I think what we need in South Africa is to encourage our public to become one that is a comprehending public. Because once we have a comprehending public, we get good debate and we have a stronger democracy. And I think, like the Minister said, this initiative will hold the ANC in good stead, will bring the media to realize that the ANC is serious about governance in this country, is serious about making South Africa a better place for all. And it's sad that the media sometimes chooses to be irresponsible, and sometimes the media chooses to be selective about not saying what good the ANC does. But I can tell you something, if the media comes to the party of a year, a lot will change in this country, and we will lead the continent. And we already see that happening in so many ways. Thank you.
Katie, you want to respond?
Thank you. And Nimrod, I'd like to respond to you. I think as SANEF, if somebody has been defamed, we certainly encourage that person to go through the routes that are already available. In the broadcasting sphere, there's the BCCSA, the Broadcasting Complaints Commission. Many media houses have their own internal ombudsman. We certainly don't encourage people to let it go, but take it up with the editors concerned. If there is anybody within that organization who you think can hear you. And last case, if you feel that there is a really serious case, I think a court of law can also assist in that way. But we're certainly not saying that any instances where people feel that they've been defamed should be let go, but we're saying take it up with the institutions that are currently in place.
Thank you, Katie. Any other comments, questions? Yes, ma'am.
Good morning. My name is Sue Valentine. I'm from the Committee to Protect Journalists, and I wanted to say, as a South African coordinating a program in an international organization like CPJ, I'm so delighted, Minister, that South Africa is taking the lead on the continent to actually redress the law. There are too many journalists, small journalists working for community radio stations in the DRC, journalists in Kenya, journalists in non-democratic states like the Gambia and in democratic states like Kenya, who have been prosecuted under criminal defamation laws in order to silence the media. And it is wonderful that South Africa can actually take a lead, and we can point to examples on the continent where Africans are taking the lead and saying that freedom is freedom, and no African should be a second-class citizen in terms of criminal defamation. So thank you very much.
Thank you, Sue. There's a question from one of our callers, Sue, Katie, to SANEF, is that when the media makes a mistake in publishing something, it normally goes, when they publish something in a sensational way, it goes front page, but the correction comes on page 6 in a very small box at the bottom. So the caller would like you to respond to that.
Thank you to the caller for that question. I think we also need to change the narrative around that. I think historically, yes, we might have seen a big front page splash with an incorrect story and then a page 6 or 7, or if you're lucky, a page 12 retraction or apology. But I think we also need to be fair and acknowledge that the media of late has been very responsible in terms of its apologies and retractions. I think we will have seen in many of our newspapers little columns either on the front page, page 2 or page 3, and I do think we need to acknowledge that strides have been made in terms of taking responsibility and being accountable for those mistakes. It certainly isn't correct to have a big front page splash with an incorrect version and then to bury the apology somewhere on page 12. But I don't think that's happening anymore, and I do think we need to be fair to our media colleagues to say that far more work has been done in this regard. It also happens in the broadcast space, and retractions and corrections are also happening quite prominently in news bulletins in the broadcast space as well.
If I may just add to that briefly, and that is to say that if you look at the jurisprudence of the Press Council in the last certainly 5 years, the standard approach, if there's been a front page story that's inaccurate and defamatory, is to order a front page apology. So there have been very prominent front page apologies in the last few years where the media get it wrong and are ordered to apologize by the Ombudsman. Of course, they may choose to apologize of their own accord, which is always a good thing if you get it wrong. The second point to make is a prominent and prompt apology mitigates any damages claimed substantially. So it's an incentive to the media where you get it wrong. And my advice always to my clients is if you've made a mistake, you mitigate harm by apologizing promptly, prominently, and of course, in any event, that is what the Press Ombudsman will order if it goes to that forum. Thank you.
Thank you. If I could just take the comment here, sir, at the back.
My name is Kenneth. Is it on? My name is Kenneth. I'm part of the Da Vinci Institute team. What I want to pose, a question that I want to pose to this community, but also particularly to the minister in terms of political direction and political guidance, so that when we make these policies, when we decriminalize or we criminalize, so that these policies, they remain consistent and they become sustainable, so that at one stage we don't see the trend that is now happening in the world where we are criminalizing, we are decriminalizing. Defamation is still going to sit with us. It is not going to change after this meeting. But though I applaud, the social responsibility that we are all demonstrating, but what are we going to do? If it gets worse in the next two months, if it gets worse in the next 5 years, what are we going to do about it? And we're not going to be tempted again to criminalize. I like what Aristotle is saying. He says that man is a political animal and is possessed of rights. And the comparison is clearly valid to the extent that the politician will continue to produce, will continue to operate a legal system. But what are we going to do? We are still going to have other social ills that are going to come. How are we going to react to them? But then my main question is that defamation is not going to disappear after this meeting. But how are we going to react to it? Because I don't want to see a future where in 5 years' time, then the minister comes back and says we have decided to criminalize. Thank you.
Thank you very much. Yes, ma'am.
My name is Shirley Lloyd, and I'm the alumni representative of the Da Vinci Institute. My question really is about the print media, radio, television, are some sorts of media, but social media, social networking is huge. And there's so much cyberbullying, which could possibly even be seen as huge defamation, leading in some cases even to young people maybe even taking their lives, committing suicide, etc. So whilst we can look at the broader media that's very visible, that we can see, how do we, and I'm taking what Les was saying, how do we look and protect people from this massive increase in the cyberbullying, in defamation, and in ruining of reputations? I think my suggestion, one of them, would be a very strong policy framework that would underpin that sort of thing. It could be seen as normal defamation. It could be seen as hate speech, which we would need to deal with. But to me, that is a significant problem that needs to be dealt with somewhere in the policy framework. Thank you.
Thank you. I'd like to give the Minister an opportunity to say something.
No, just a few words, just to thank all the panelists and those participants in this very important debate on decriminalizing defamation. Somebody asked whether we can be able to disseminate this very profound and progressive development in South Africa to the continent as a whole. My answer to that is that we're going forward as a continent. We cannot behave as if we're still in the era of Homo naledi. We are in 2015 now. We have Agenda 2063. We talk about a free trade area for Africa. We talk about regional economic integration, infrastructure development, all areas of good corporate governance. So in this area, I believe that the word is going to be spreading. And in fact, it is spreading. Last week only in Mozambique, the judge, when two prominent economists, Franco Banco and Mbanza, a journalist, were being charged for libelous activities when they issued a Facebook in 2013 criticizing the government of President Gebuza, the judge ruled that that cannot be regarded as libelous. So already you can see that the winds of change are blowing on the African continent. So we have no hesitation as the ANC that we believe in our constitutional democracy, in the rule of law, in the freedom of speech, of expression, of association. So this consensus that we have reached here today of going to our courts, High Court, even to the highest court of the land, the Constitutional Court, I'm sure sooner or later the whole of Africa may be able to follow suit so that we build an Africa of our dreams, the Africa of Kwame Nkrumah, who wanted the whole of the African continent to be totally liberated, not only physically, but also mentally. I thank you.
Thank you, Minister. Advocate Hlakula?
No, I just have a small point to make that Ghana decriminalized many years ago, and also Niger. And as we look at going forward, we can, look at Ghana and see what happened after they decriminalized the defamation. The skies did not fall. The media is free. So I'm simply saying that going forward, Minister, in trying to take this debate forward, we can look at the countries that have decriminalized and look at the media landscape and look at whether in those countries defamation increased or not. I just thought I should put this on the table. Thank you.
Thank you very much. Any further comments, sir?
Thank you. My name is Zunati. I'm actually an engineer, and maybe I shouldn't be here. I think for me, there are social, moral issues that need to be addressed. Whether you criminalize or don't, you won't resolve that. Also, I think when it comes to the powerless, if defamation happens between the defamer can also be powerless. So in other words, if you then say he has committed a crime, and the social consequences of them having a criminal record and what those consequences are. So I think we must find a balance and really look where there's a acute problem and address an acute problem. But I think to keep it in some form because the power of the powerless, which in most instances don't even know that they are committing a crime. They are not aware that by defaming someone they are committing a crime. Or the person who's being defamed does not understand that it's a crime for them to be defamed. As a result, this never sees neither the civil process nor the criminal process. So even if you do keep it that way or criminalize it, you would have to really educate the powerless. Because without that education, they don't know actually what's happening. So that's my point. Thank you, Chair.
Thank you very much. We're going to go to a short commercial break and we'll start rounding up this debate. Thank you.
When you go up, we're not going to give you that other mic, we'll give you one of these things. Good, thanks. Sven, did this red mic break up? I had a clipping. I'm going to use it for the gentleman that's going to do the closing. Okay. Yes, it is.
Can we not do it the other way? Do it the other way. Okay. Okay. So we're going to Ben now and then the comments. No. Now I want to give the three panelists 1 minute each to wrap up. Yeah, okay, 30 seconds. Huh? Keep yours. You first.
Yeah, if you want to talk to me, you can solo this one and I can talk to you on it. Display mic. We're going to try and do it all with the two handles. We're going to... One, two, one, two, one, two, one, two, one, two. This is blue. Okay? This is blue. Yes. Yeah, that was spare. This because the other one's down. So this one becomes blue. Have you got it now? And red is still red. Thank you.
Thank you. Welcome back. We're getting to a close on our debate. At this stage, my task is to thank the Da Vinci Institute for hosting us here this morning and to hand over to Professor Benny Anderson to say a few words and to acknowledge certain parties. Thank you.
Thank you very much, ladies and gentlemen. We would like to start by saying these events not only just happen, they happen because there are people, real people that believe in what we want to achieve here. So we in particular want to say thank you to Dina Pillay, a colleague from our business community who has sponsored the advertorial for purposes of this workshop. And this has been done in memory of Gavi Pillay, who you may know has been a well-known human rights lawyer during the 1970s. So we are particularly pleased for the support from that side. We also want to say thank you to our three presenters who took the time out of their hectic professional lives, Dario Milo, Les Morris, and Moshweshwe Munare, for bringing inputs into this debate. We really appreciate that. This is also made possible because of the support of the SABC in broadcasting this event, and both on radio, SAFM, as well as SAB News Channel 404. Then also we want to acknowledge the contributions and the support and, well, the contributions of the ANC Legal Group and their colleagues who've been here today, in particular Mr. Chris Schneider for the preparation and the work done so far. We also want to say thank you for the presence of the Honourable Minister Jeff Radebe for joining us here today, as well as the presence of Advocate Panzit Tlakula. We really appreciate both of you taking the time to be with us. There's also appreciation from our side for the involvement of SANEF and their delegation under the leadership of Moshweshwe Munare. We are pleased to have joined hands with them in this process. There's also the civil society organizations that are present here today, and we hope that this will be a start of a dynamic debate, not just around criminalization and defamation, but for ongoing debates that we're anticipating for the near future. The members of public and the viewers out there, we also want to say thank you for you already joining us in the process. I see on the Twitter feeds that there's quite some activity happening there. And then, ladies and gentlemen, the role of Da Vinci in particular is we heard a lot about the powerless, and there was reference made to the unfortunate. And as an Institute of Higher Learning, we hope to assist in going forward in facilitating and opening up the debate. It's all good and well that we are the privileged, we are the power that are able to be here today and to share and to talk and to discuss. But our intent is to take this debate post today for the next 8 weeks to a broader forum of people representing broader civil society. And we are prepared and made a commitment to tell the story to a broader audience and to facilitate more awareness amongst other people outside this room around defamation and around criminalization. And we will, post the 8 weeks from today, Da Vinci will present a minute that we will circulate to broader society and to policymakers to inform the process going forward. Thank you very much.
Thank you, Professor Benny Anderson. Give our panelists 30 seconds each to round up.
Thank you, Krish. I'd just like to say thank you to the Minister. Beg your pardon. Thank you, Krish. Thank you, Mr. Minister Panzi Tlakula, for your contribution today, for your leadership, and to the audience. I appreciate your contributions today, and thank you for the opportunity of addressing you on this important topic.
I'd like to just say, as a media lawyer, I'm obviously very, very happy with the announcement today. It strikes the correct constitutional balance. As a citizen of this country, I want to say I'm proud of the ruling party of my country today. And it's a very, very good day for freedom of speech, for the right to know, and for our democracy. Thank you.
As SANEF, it's unfathomable for us to think that in 2015 journalists could face arrest under this Criminal Defamation Act. We therefore really welcome the discussion and the debate today and look forward to the day when criminal defamation will officially be declared unconstitutional and unlawful. And we certainly welcome any further discussion as we get to that. Thank you for your time.
Thank you for everyone. Thank you to our viewers. Thank you to our listeners. And let's give ourselves a round of applause in this audience this morning. And as many speakers have said, Professor Benny Anderson and others, that this is just the beginning of a process. And we certainly want to take up the challenge or the recommendation by Minister Kadebe and ANC that we are going to work towards the eradication of criminal defamation in South Africa. Thank you very much and goodbye.